There you go.
All right. Tanner, I'll go ahead and start over. All right, the matter before the court is case number SWSW002810. This is the time set for hearing on a motion to unseal the search warrant in this matter. Application having been filed by attorneys Nellie O'Mara and Jesse Marzin, who are present. The state is represented by County Attorney Carlisle Dalen. Counsel, are there any preliminary matters that we need to address?
No, Your Honor.
No, Your Honor.
All right, Ms. O'Mara, Mr. Marzin, you may proceed.
Thank you, Your Honor. We call Steve Ridge to the stand.
If you'd come forward, sir, right up over here. If you'd remain standing and raise your right hand, please. Do you solemnly swear or affirm that the testimony you are about to give in this matter shall be the truth? Be seated.
Mr. Ridge, there is a button at the bottom of your microphone there, if you can push that.
I see it.
Perfect. Please state your full name and spell your name for the court reporter, please.
It's Stephen Eugene Ridge. I go by Steve Ridge. It's STEVERIDGE.
What do you do for work, sir?
Well, I'm a licensed private investigator, but all of the work that I do relative to cases like this is pro bono.
How long have you been doing that work?
5 years.
And what state are you licensed through?
Iowa.
Excellent. You are current on all such educational requirements to hold that position, that license?
Yes.
Excellent. You are familiar, are you not, with the items described in the search warrant file, are you not?
Yes, I am.
Specifically, that is a 1999 Honda Civic and a 2013 GMC 1500, correct?
Correct.
Are you aware to whom those items belong?
Yes.
Who is that?
That would be John Van Sice, formerly John Van Sice, and his wife, Jane Brunette. The Civic was licensed to Jane, or owned by Jane, and the pickup was owned by John.
And have you had a chance to physically observe these two vehicles before?
I have, out in Arizona.
Okay, so you have both visually and through conversation confirmed the ownership of those vehicles, correct?
Correct.
Tell us about your contact with the owner of this vehicle.
I first made contact, it's been 5 or 6 years ago, by phone, and eventually I made multiple trips to Phoenix area and visited the residence of John Van Sice multiple times.
Have you maintained communication with him since that time?
I have maintained limited communication with John, given his deteriorated health. I have maintained a steady flow of information and contact and communication with Jane Brunette, his wife.
And today as we sit here, are you aware if Mr. Van Sice is alive or dead?
I am quite certain that he is dead.
Okay. Do you know when he passed away?
It would have been December. I'm going to say December 6th, give or take. I think that's the date at which his wife notified me that he had finally passed.
Okay. And just for clarity in our record, you are talking about December of 2024, correct?
Correct.
Thank you. You have requested that this search warrant be unsealed, correct?
Correct.
All right. And are you aware of any disclosures made by any law enforcement officers regarding this search warrant before?
Only what I know as a public comment that had been made by the police chief, that it did not result in anything.
That's all the questions I have, Your Honor. Thank you.
Any cross-examination?
I have no questions.
You can step down. Thank you. Any further evidence, counsel?
No further evidence, Your Honor.
Are you offering any evidence, Mr. Daly?
No, Your Honor, just
All right,
argument.
I'll hear from the applicants.
Thank you, Your Honor. First of all, under 808.13, confidentiality, all information filed with the court for the purpose of securing a warrant for search, including but not limited to an application, an affidavit, shall be a confidential record until such time as a peace officer has executed the warrant and has made the return therein. And Your Honor, under 804.29, it also explains what confidentiality is and how long that it should be, a search warrant should be confidential. Both of these state that a search warrant should only be confidential until that it has been made a return of. And it's our understanding through the public comment by the Mason City Police that the search warrant did not result in anything, that the return has been made on the search warrant. Secondly, Your Honor, the state has no right to conduct an investigation after a person is deceased. A criminal action abates upon the death of a defendant, as punishment cannot be imposed to a deceased individual. And we quoted case law in our motion to unseal this search warrant. Your Honor, Mr. Van Cise has passed away. There is no further information that the Mason City Police or Cerro Gordo County can receive from him. The family needs closure on this, Your Honor. They need this opened up and unsealed so they can receive closure after his death, to know that he is no longer being investigated for something he can never be charged with.
Anything further?
Yes, Your Honor. Your Honor, I am specifically addressing the issues raised by the state in their response to our motion to unseal the search warrant in regards to Iowa Code Chapter 22. Now, Judge, it is obvious from the face of our motion that we are seeking investigative records, okay, as classified under Iowa Code Chapter 22. The state cites in their resistance an exception to the open records laws in Iowa Code Section 22.7, subparagraph 5. Now, our Supreme Court has been very, very clear, Your Honor, in what steps and what tests have to be used when that is being analyzed. It is the case of Hawkeye versus Jackson, an Iowa Supreme Court case from 1994 that sets out the three-part test that a court must walk through when they are faced with this issue. Now, as to the first issue that the Hawkeye court mandates, the question of whether a public officer is being examined, well, here, Your Honor, we are requesting information from the clerk of court, from documents duly filed with the clerk of court, who is obviously a public official, pursuant to Iowa Code Section 602.1215. As to the second prong of the Hawkeye test, in that the communication was made in an official confidence, I think it goes without saying that a police officer's or other law enforcement officer's statements to a magistrate in search of a warrant does meet that test of whether those communications were made in an official confidence. It's this third prong of the test, though, Your Honor. The public interest would suffer by disclosure. That's really where the heart of our argument goes to, Your Honor. The state has no right to investigate or to prosecute a deceased individual. The subject matter of this warrant was specific to that individual, Your Honor. The chief of police has already come out and said that the search revealed nothing or nothing of interest, something to that effect. What we seek here, Your Honor, is the documents that merely corroborate the disclosure that law enforcement has already made regarding this specific search warrant. We're only talking about this search warrant, Your Honor. We're not looking to go any further than this search warrant, but this is a public record that now, as we sit here in 2025, should be unsealed and should be made available to the public pursuant to the relevant statutes, Your Honor. Ultimately, Your Honor, the test here is whether the public interest would suffer by the disclosure. Your Honor, I think it goes without saying that the public has an interest in knowing what police are doing, in corroborating what the chief of police has already said about this. I believe that this family, Your Honor, also has an interest in clearing the name of this individual who lived the last years of his life under the cloud of suspicion and accusation based on this situation. We seek, Your Honor, to give in death what the state has robbed of this man during his life, and that is a clear name. We ask you to unseal this search warrant and give this family some finality, Your Honor. Thank you.
All right. Mr. Dalen for the state.
Thank you, Your Honor. Just so the record's clear, I'd like to begin my statement by saying since June 27th of 1995, we have been investigating this case and will continue to investigate this case. I think it's important when we look at this case, we go back a little bit and talk a little bit about how this came about. In February of 2017, law enforcement put together information that they thought would warrant a search warrant. Now, I know the court is well aware of this, but I want to talk about it anyway. Because a search warrant is something that you need to take in front of a magistrate, and you need to have to explain yourself. You provide an affidavit that explains why you now want this warrant. And in this case, that's what they did. They put an affidavit together, and in this affidavit is case facts. It's case facts and circumstances that go all the way back to June of 1995. And they have very specific information about the case. They also have information of how they're working the case. And they do that so that the magistrate or a judge has the ability to look at that and say, yeah, I understand. And that makes sense. And because of that, I'm going to sign this warrant. And in this case, the magistrate did sign the warrant. They executed the warrant, and then they returned it. Now, the only thing different about this case is the fact that they came to me and said, Mr. Dalen, there's a lot of facts and circumstances in this case that we do not want in the general public. That is going to affect our ability to do our job. And that's what happened. I went downstairs and talked to the magistrate, explained it, and actually it was the same magistrate that signed the warrant. And that magistrate said, yeah, that makes sense. And in that order, I think it's important to point out that in that order, the court determined that there is a substantial probability that the state's ongoing investigation would be severely compromised if the documents were to be made public. That was in the order signed by the magistrate to seal these documents. Now, since then, we moved forward. We have 7 years, because in this case, the magistrate said, well, I only want to extend the sealing 1 year. Let's reevaluate it. So for 7 years, I've gone down to the magistrate's office, had them review it, and they've made the same conclusion, again, the same conclusion, that there is a substantial probability that the state's ongoing investigation would be severely compromised if the documents were to be made public. So we've had a history of judges looking at this and saying, no, we need to keep it sealed. So what's changed? Now, the only thing that's changed is that Arthur John Van Cise has passed away. But that doesn't mean that this investigation is over. That doesn't mean that we're not going to still investigate, because ultimately we want to find out what happened. And obviously we have not charged anybody yet. So there is nobody that's been charged in this case to date. So we're still trying to figure out exactly what happened. That's an ongoing investigation. Now, the defense points out a couple things. First, they talk about the state has no right to conduct an investigation after a person is deceased. Well, I respectfully disagree with that. Again, we're not going to stop this investigation until we do find out what happened. Now, they put a case, State versus Griechbaum, and that's Kriechbaum. That's the case that they cite for the fact that we can't go further with our investigation regarding Mr. Van Cise. Well, if you look at that case, Judge, it's a case where a defendant was charged, he was found guilty, and sentenced. The only issue in that case was, can you assess the defendant costs or their estate costs? And the court said, well, no. There's an abatement there. The criminal prosecution abates the action when somebody dies. Well, there's nothing to abate here. There's no action here. Nobody's been charged. You can't abate something that hasn't even been charged yet. So I don't think that has any relevance in this case. We move on to another argument that they make in 808.13. And she read 808.13, and that just basically talks about how you get a warrant. And when you get a warrant, that is automatically sealed by the court until the return of that warrant. And that's what happened in this case. But nothing under 808.13 says you can't get an order sealing those documents. We do it all the time. We do it in drug cases where you search somebody's house and you find some things and you want that CI to do further buys. Well, we seal the search warrant so that the public doesn't know that we're conducting an investigation and that there's a CI out there. So sealing a search warrant is nothing new as far as magistrates' orders to seal. The next argument that they made is that the court does not have the authority to seal a search warrant. Well, again, I respectfully disagree. If you look at the 8th Circuit, this case is in re search warrant for secretarial area outside of office of Thomas Gunn. That's an 8th Circuit federal case, and I think that really speaks to this. It was basically the same types of facts. A newspaper filed a motion to unseal documents supporting the issuance of a search warrant. And basically what this court said, well, there's an ongoing investigation here. They said documents may be sealed if the district court specifically finds that sealing is necessary to protect compelling government interest. And they went on to say that refusal to unseal documents was appropriate where there was substantial probability that government ongoing investigation would be compromised. And that's what we're saying here. This completely supports the idea that sealing a document, sealing a search warrant is appropriate when there's an ongoing investigation. What they're saying is that, well, open it up, Judge. Well, here's the problem in opening it up, is that opening it up gives everybody facts and circumstances of this case that aren't out to the general public. If you have a witness, or if you have somebody that comes in front of law enforcement at this point in time, and they say certain information, how do we know whether they're accurate or not if all of this information is out to the general public? You can't figure out if they're telling the truth. But if only the officers know, and this is information that only the officers know, well, then they can evaluate whether that person's telling the truth. There's a lot of reasons why all of these facts and circumstances shouldn't be given out to the general public. A couple other things that they brought up. They brought up 22, that analysis that every person shall have the right to examine and copy public records. That's not a problem. People have the right. If it is a public record, then they should have the right. But again, and Mr. Marzen brought this up, confidential records. 22.7. If you look at paragraph 5, it specifically says that peace officers' investigatory reports of law enforcement agencies, if that information is part of an ongoing investigation, those are confidential. it's clear what they want to do. They want to open up this case and they want to provide more information out to the general public. This is what I want to conclude with, Judge. There's a lot of law enforcement officers that are working on this. You have the MCPD working on this, you have the DCI, you have the FBI, and now you even have the cold case unit down at the Attorney General's office that are working on this. He is telling me that providing this information in that affidavit is detrimental to their investigation of this case, that it will hinder their investigation. All of them are saying that. I have no idea why, when we have a difficult case, that it makes any bit of sense to open up these records that law enforcement are telling us will hinder their investigation. I have no idea why that would be a good idea. So I'm asking that you deny their motion and also extend that sealing of that search warrant for 5 years, based on whether the court wants to open it up or something else happens. I mean, we all know that if somebody gets charged in this case, there's no question, through discovery, they're going to get all of these records. I open up my complete drawers through discovery and say, here you go, build your defense. This happens on every case. But in this case, this is an investigation. Nobody's been charged. And therefore, I'm asking the court to deny their motion. Thank you.
Any response?
You go first.
Thank you, Your Honor. First thing I'd like to address is that Mr. Dalen said that the DCI, the FBI, the cold case unit, they're all telling him, don't open this up. Where are they? He didn't call any of them as witnesses. So it's just his word that they're all telling him not to open this up. But he did not produce any evidence to show that this is still under investigation and where the investigation currently is at. Secondly, while Mr. Dalen quotes the State v. Kretschbaum, he also fails to understand Woodbury County Attorney versus Iowa District Court for Woodbury County, which is 448 Northwest 2nd, Iowa, 1989. That case is where a civil person requested the information in a criminal case from a defendant who had been deceased. And the court ruled, first of all, that they can do this, but the procedural way to do this is through Iowa's Freedom of Information Act. And so, Your Honor, that is exactly what we have done. The Supreme Court ruled that in 1989. We're following the procedures that they have set out. Mr. Van Cise is deceased, and that is why we filed this, Your Honor. His family does need closure for this.
Mr. Dalen, anything further?
Just a quick response, Your Honor. I have to speak in the abstract. I cannot bring an officer in here to talk about what's in that affidavit. Again, that would be senseless for me to do that. This is argument that's presented to the court. It's based on case law. It's based on the facts of this case. So, in this case, again, I'm asking that you deny their motion. Thank you.
So, Mr. Dalen, what's the court's role in determining whether unsealing the search warrant would compromise the investigation? An independent determination of that.
I have no problem if the court wants to look at that affidavit in you looking at the affidavit to determine, it's part of the case file, to determine whether you believe there are facts and circumstances of the case that would compromise the investigation. I have no objection to that.
I'm pretty confident that I'm excluded from the unsealing order. I think the court has the authority to look at it, but in terms of determining, okay, do we have information here that, if made public, would compromise, ultimately I'm thinking that that's my determination to make, giving input to what you've had to say here today.
Yeah, that's my understanding, that it's your decision to make. given those factors and given the case.
Any disagreement with that, counsel?
No, Your Honor.
Right. And Mr. Dalen, I'm assuming, I understand the argument you made, and their motion does state no right to conduct an investigation, but I think, as I took the statement, that meant with respect to Mr. Van Cease or Van Cise, how is it pronounced? Is it
I believe it's Van Cise.
Van Cise? But you're talking about he can't be charged, so you can't investigate him, if I understand correctly, right?
That's correct, Your Honor.
Okay. My next question, and you can both speak to this, does the court have any authority to unseal portions of the file, or is it an all or nothing situation? And if you need time to look into that, I'll give you that time, and you can let me know if you find any cases.
Your Honor, I believe that the language of the statute allows for the court to determine which portions can be unsealed, which portions can't be unsealed, and I think the court gets to make that determination based on the factual record that is before it. Again, that's part of our struggle here, Judge, is that there's been no officer to testify that, first of all, that there actually is an investigation. Number two, what stage of the investigation is at. Number three, which portions from this search warrant obtained back in 2017 may or may not still be relevant. Again, we have no facts upon which to base any type of sealing of this warrant. That is our position. In the alternative, we do believe that the language of the statute, as well as the case law surrounding it, allows the court to make that independent determination, again, based on the record in front of it.
Mr. Dalen, do you have any position on whether it's an all or nothing situation?
I don't believe it's an all or nothing. If you look at that case that I quoted for the court, in-ray search warrant for secretarial area outside office of Thomas Gunn. If you look at that case, it does talk about there was a request for a line-by-line redaction, and the court found that a line-by-line redaction of sealed documents was not practicable and posed a danger to government's ongoing investigation. I don't know how you look at that affidavit and pick apart what's, I guess what's not relevant or is relevant. It's our position that the entire thing is relevant, needs to be sealed, and that's what we're asking the court to do, is seal that document.
Mr. Dalen, what role does passage of time have on this determination? It's been a long time.
Yeah, actually, this was one of my first cases, actually, when I got to the county attorney's office, and I started in '93, but you don't need a history lesson. But yeah, it's been a long time, but this investigation is no more slowed up because of anything. It's a long investigation, it's very difficult, but it's ongoing. In a lot of cases, you have new technology, you have new things that might draw light to your investigation. Sometimes you have some eyewitnesses that come forward at a later date. That's why a lot of these people are here supporting it, because they're still involved, all of these people, in this process. And that's why they're keeping it active. It's the 30th anniversary. I shouldn't say anniversary, I should say 30th year that we've been working on this case and to try to get a solution. But they're having something this summer to try to get more information and more help with this case for law enforcement.
Do you think the passage of time weakens the argument that it might compromise the investigation at some point?
Actually, Your Honor, to be honest, I don't think that, because a lot of the stuff that's in that affidavit, without sharing specifics, is about the first day of the event and things that they saw, things that are in reports. Police officers made observations. A lot of that information is in that affidavit. That will never change. I mean, as far as that they can use that in the future if they have witnesses or if they have defendants to corroborate or not corroborate that information. Again, that doesn't change. And so I don't think that the passage of time has anything to do with what we're looking at here, information in a search warrant that's used in an investigation.
All right. Counsel, any responses to any of that?
Well, I think, Your Honor, that the state has given you quite a conundrum there where he's saying that's the 30th anniversary and they're trying to get more help for the investigation, yet he's not even willing to unseal a search warrant that may have information in there that people may know, that may be able to help out with the investigation. So I think he's really contradicting himself there, where he's asking for help with the investigation, but yet won't release the information that may help with it.
All right. I will take this under advisement. I need to look at the cases you provided. I'll also do my own research into the matter, and I would intend to be able to file a ruling within 30 days. This matter is concluded.
Thank you, Your Honor.
Thank you, Your Honor.
So you guys are free to speak to the media. I don't know if they'll try to approach me or not. If they do,